Hello to my NRI friends. Today we'll speak about what happens to an NRI's assets in India after death. A flat in Mumbai, a bank account, mutual funds, insurance, ancestral land. These are the assets an NRI can carry. When an NRI passes abroad, these assets don't transfer automatically, and families are often left with difficult questions. The estate planning, NRI guide, and legal process. This is where we help our NRIs. I am Arun Kumar Sharma, NRI Financial Services, and you can contact me for any NRI financial services on these mobile and email ID. So we care about your money, insurance, investments, and wealth. So let's begin. What happens to an NRI's assets in India after death? What assets can an NRI own in India? First is the real estate like residential flats, inherited agricultural land, bank accounts, savings, fixed deposits, NRE, NRO accounts, investments, shares, mutual funds, and gold, and of course, insurance. But one critical factor that determines everything that his assets, NRI's assets, smoothly transfers to their successors. Did the person leave a valid will? So we will address this question in this presentation. Scenario 1. NRI dies with a valid will. The will is the primary document. The executor begins asset transfer to the named beneficiaries. So in the document which a successor needs to submit for transfer of assets, the death certificate of NRI, original will, and probate if required. So even if will is written in foreign country, it is recognized in India provided it sufficiently meets the legal requirements. Now scenario 2, NRI dies without a will. This condition is known as dying intestate. India succession laws decide who inherits now. So if there is no will, now the law will decide how the wealth of NRI will be distributed among the family members. So if you are a Hindu, Sikh, Jain or Buddhist, your assets distribution will be governed by Hindu Succession Act. Spouse, children, mother are the primary heirs. For the Muslims, the asset distribution is governed by Muslim personal law. For Christians and others, governed by Indian Succession Act. So what happens? Without a will, family assumptions don't apply. If family decides to own something, they cannot decide on their own. Now the law will decide who will get what. So assets distributed by the law, not by what the family expects. This is where most inheritance disputes begin. So estate planning prevents years of legal battles. If you have properly done estate planning with a professional and developed a will, you are surely going to smoothly transfer your assets after death. Now, documents that family will need. So, first, foreign death certificate may require apostille or legalization if Government of India offices demand for this. Then passport copies of the deceased NRI, proof of relationship like marriage certificate, birth certificates of the wife and children respectively. Legal hire succession certificate issued by Indian courts if there is no will already written, and probate order wherever applicable. Just take care that the names across the document should be same. If there are mismatches in the names, then there will be significantly difficult issues and there will be delays in transfer of assets. So just check that all the documents of your assets, nominations in those documents, whatever be the name, they should be same across. Now, real estate, what happens next? The property doesn't transfer automatically. Legal heirs cannot simply take possession. Ownership records must be formally updated. So, you need to prove inheritance, submit a will or succession certificate, and succession certificate you need to get it issued by the local body authority, administrative authority. You need to update the records with local municipal authority, then pay applicable duties, stamp duty for whatever state you have the assets. This duty you need to pay accordingly. Bank accounts and investments, and it includes insurance also. So bank accounts, a nominee is a custodian, not automatically the owner. Banks require documentation before releasing the funds. So a will is important. Barely nomination will not protect your assets from being claimed by others. Mutual funds and shares transferred via transmission. Heirs submit documents to transfer investment to their names. So whichever broker you have for the demat account, you need to apply the transmission, and for the mutual funds. Fixed deposits and lockers. Banks follow specific procedures. Updated nominations make the process significantly easier. So just make sure that you check all the nominations in the documents, and of course should be supported by updated will. Now, common myths which I am going to bust before you. The nominee becomes the legal owner. Not necessarily. A nominee is often a temporary holder until legal ownership is established. So, nominee cannot be the legal heir. That we should understand. A foreign will is invalid in India. Incorrect. Foreign wills can be recognized if they meet legal requirements. So, you need to check if you have made will in foreign country and get it checked by a professional in India, so that if there are any legal requirements needed for the validity of the will, that can be done in advance. The property transfers automatically to the spouse. No, it doesn't happen. No, legal procedures are always required to update ownership records. So you must take care of this, that your property does not transfer automatically to the spouse. Please take care, because most of the disputes come in the court because of this particular myth. Now, how to protect your family from these unnecessary litigations and disputes for the transfer of the assets? First, create a will. Covers both Indian and foreign assets. No matter you own an asset in foreign country or in India, you must create a will. Update nominations in bank accounts, investment and insurance, and wherever you have invested, you must update. Maintain these records and update property documents and account details. These must be maintained actively. Review it every 6 months. If any changes are required, do it. And of course, these are the complex legal matters. You can consult a professional and estate planner or a legal advisor for smooth documentation, and your next generation don't face any problem in transfer of your assets. So takeaways from this particular presentation: have a will, reduces disputes and speed up the transfer of the assets. Keep the record, proper documentation prevents delays. Know the law. Indian law governs Indian assets and foreign law governs the foreign assets. And definitely seek a guidance from professional. That advice simplifies everything. Estate planning isn't about expecting the worst. It's about protecting your family when it matters most. So thank you very much. If you liked this particular presentation, please do subscribe, like and share this to all the NRIs who are in contact with you or in the NRI communities, so that they don't feel any problem, they don't face any problem while transferring their assets to their next generation. So thank you very much. See you again in the next NRI Financial Services presentation. I am Arun Kumar Sharma, and you can contact me for NRI Financial Services. Thank you.